In this video, we're going to discuss enforcing your trade secret rights when you think someone is about to misappropriate those trade secrets. As we've discussed in a prior video, generally speaking, to have trade secret rights in your sensitive information, there has to be economic value in that information and in the fact that your competitors don't have access to that information. And you need to take reasonable steps to keep that information secret to your company. Someone misappropriates your trade secret rights when they obtain your trade secrets or reveal those to the other party through improper means. One preliminary note is that time is of the essence if you think someone's about to misappropriate your trade secret rights. That's because some of your trade secrets may be so important, there may not be an amount of money that would be adequate for you to receive if your trade secrets really are revealed to a competitor. And it's hard to get those secrets back into your company and out of the hands of competitors once they have been misappropriated. Therefore, it's important to move quickly in adopting a strategy. Quite often, that strategy will involve going to court to seek what's referred to as injunctive relief. Injunctive relief refers to a court ordering someone to do something, or in the case of trade secret misappropriation, not do something. For example, you could seek a court to order an injunction that would stop an employee of yours moving to work for a competitor, or stopping certain information from getting into the hands of one of your competitors. For a court to order injunctive relief, they're going to look at four factors. The first is the likelihood of your success in the merits. How likely is it that if the case were to proceed through trial, that you're actually going to win on the merits? The second factor is whether the harm would be irreparable if the court allowed the alleged wrongdoing to actually take place. So if your trade secrets are to actually be misappropriated, how bad is the harm to you, and would monetary relief be adequate? Because if there is some amount of money the court could order the wrongdoer to pay you, then the court's just going to say, let's handle this like any other case, let's go through the litigation, go through trial, because money's enough in the end if you're actually right. On the other hand, if the harm is irreparable, the court's more likely to take action sooner rather than later. The third factor is what's called balancing the equities. So balancing what's the hardship on the other party from ordering this injunction, from stopping the employee from leaving you and going to work for your competitor, versus the harm to you if that employee is allowed to actually go and work for the competitor. And the fourth factor is the public interest. How important is this issue to the public at large? One special form of injunctive relief is called a temporary restraining order. That's where this is a significant emergency for you, and so you're going to go to the court seeking rapid relief. And typically a temporary restraining order is going to be issued only for a short period of time, maybe 10 to 14 days, to stop something that would otherwise happen when you're able to show, based on those four factors, that you really need the court to stop this from happening before the court's even able to address the merits of this issue. One last thing to consider before running to court, if you think someone's about to misappropriate your trade secrets, is what is the total cost of this litigation for you? Not just the cost of your attorney's fees and the filing fees at court, but the publicity that's going to be brought to your own conduct. If you're seeking injunctive relief, the court's going to make sure that you're not operating with what's called unclean hands. So if maybe your conduct has not been perfect, you may want to consider whether you want to bring publicity and scrutiny to your own conduct. By running to court, you're going to draw your competitor's attention to this information, and maybe it's better just to not draw attention to the information and just let it go. And the last thing to consider before running to court and starting litigation over trade secret misappropriation is just what's the perception of you going to be as a company doing this. There is some risk that you could be perceived as a bully, especially if you're bringing this action against a current or former employee. And thinking long term about your ability to attract talent to your company, do you want to be perceived as the type of company that would bring this action? So those are some additional things to consider before bringing legal action. And this has been a general overview of how to enforce one's trade secret rights.